your memory. So I said they split statutes. The one statute that might apply to you into three sections. The tax imposed or whatever's imposed, the liability for it, and then the penalty statute. It's like a jigsaw puzzle. So just be aware of that. And if they ever try to prosecute you on 7201 or these others, you say, am I the person who? I am. They don't want to answer that, by the way. And then they do in one criminal case, the prosecutor got up and said, well, 6012 imposes the tax. 6012 doesn't even have a regulation. 0 regulations. So it doesn't apply to the general public. So 6012 doesn't do it. And if you can tell the court that, you'd be in good shape. So that's remember the regulation requirement, because you're almost always going to find it out with the regulation. Now, how can you tell if a regulation is promulgated by the secretary and if it applies to the public? Because there's more than one kind of regulation. There's a directive, regulation. There's only one that applies, so it's a legislative regulation. And a legislative regulation means that the legislature authorized that regulation. Anyway, how would you tell if it applies to the general public? Well,
Register. Federal Register.
Yeah, but are you going to look at the Federal Register for it?
I tried. It's so big.
Okay. You would look at the bottom of the regulation for one thing. It cites all the authorities that the regulation itself is based on. Okay, and if it's all Treasury decisions, it doesn't apply to the general public. If it has no statute referred to at the bottom, like a few of them do have statutes cited on the bottom, and that means Congress passed that statute or law, and that regulation is based on that law.
So you look for statutes at the bottom of the regulation?
Yeah, look for statutes or code sections. Yeah, then it would apply to the general public. We have the circus court out in San Francisco that gave us a nice ruling. And they said TDs do not, Treasury decisions do not apply to the general public. Yeah. The Secretary of the Treasury doesn't pass law. And if he writes a regulation and doesn't have a basis in law stated at the bottom, then it doesn't apply to the general public. You also look at the parallel table of authorities. What is the parallel table of authorities? What's the point of it? Why do they have it? Why is it updated 2, 3, 4 times a year by all the heads of the government departments?
It's a list of all laws that are currently in effect.
Yes, you're right, but I'm not sure you're getting to the point. The point is that
Implementing regulations.
they have to match a statute up to a regulation. And they don't list all the regulations that there are. They only list the regulations that are implementing regulations for that statute or code section.
Remember, it's a table of authorities, so
Yeah.
you're finding out where the authorities are by matching them up with regulations,
Right.
if there are any.
Yeah, if there are. And in fact, you will see some that are not even listed, like a IRS code section will not even be listed. Of course, there's no regulation on the other side either for it. So that would mean that there's no regulation either in Title 26 or Title 27. So if there's nothing there, it means the Secretary hasn't promulgated any regulation in Title 26 or Title 27. So, and the way you really can prove that is because if you look at, you go down through the code section, say 6331, okay? And they have dots across, and they'll list the regulations, the Code of Federal Regulations on this side, CFR. And these are the US codes, okay? You will see in some of these lines, as you go down, you'll see Title 27, and it's written like 27, Part 70, or Part, whatever, maybe other parts. Sometimes, in this particular, with this particular statute, you will see 27, Part 70. Part 70. And that means you got to look to Part 70. Well, what is CFR Title 27, Part 70 saying? Well, I can tell you, there's several regulations. There's probably about maybe 6 or 7 or 8 of them strung out in 27, Part 70. If you look on the internet, you will see them down there. And you will see one of these regulations says, what is it? It says delegation from the Secretary. And that's the regulation that delegates from the Secretary. And you know what that regulation does? It cites the delegation order to who? 27 CFR is to the ATF agent. And that's exactly what the regulation says. It says, it cites who the regulation is delegated to enforce. It's the ATF agent. And it cites the delegation order number. There's an actual number there. It's where you will find. But it doesn't, there's nothing in 27 CFR Part 70 that cites an IRS agent and never cites a delegation order for an IRS agent. And if you look at the overall framework of it, it says for alcohol, tobacco, and firearms. So you have to go to 26 CFR. 26 CFR to even try to find a regulation for income taxes. That would be in 26 CFR, because that is titled income taxes. And most of these statutes will not cite 26 CFR, they cite 27. Almost all of them. Well, you get a lot of 26 CFRs, but if you go in and read the regulation, it gives no enforcement authority to IRS agents. In the 1954 code, and Schiff, I think, brought this out first. He says that in 1954, they eliminated all the enforcement statutes for the income tax. So in other words, it's simply there, sitting there, the tax imposed with no enforcement. Follows. It's missing there. That's the levy statute. Also, 6323 is the one they also cite on the notices of lien, and that is also 27 Part 70 of the CFR. Alcohol, tobacco, firearms. Period. There ain't nothing else there. That's how we can prove that the parallel table of authorities is there for a particular reason. And you know what, prosecuting attorney in Grand Rapids, I was sitting across the table from arguing this. He says, I don't think the parallel table authority means what you think it means. I said, okay, are you going to go in front of the jury and say that they just made up this table and then they picked at random, 27 Part 70, 26 Part 3, and they just randomly stuck different regulations down opposite each code section, and he changed the subject, which is what attorneys do. So, but he was not willing to argue that in front of the jury. So they put pressure on the defendant not to have me testify on these. And the defendant caved in. Defendant spent 3 years now. Yeah, I know. But I'm telling you, you pick on the weak people and the people who are ignorant. So if you show them what you know what you're doing, you're not going to pick on you.
If you would have insisted on his right to have a witness under 601,
Yeah.
you know, there'd be no problem. The jury would have heard the truth,
Right.
and that would have influenced their decision.
You know what? He wouldn't have even been in that trial room if he insisted on a witness.
You know what, you're right, you wouldn't.
He wouldn't even
Because
gone
they
to
couldn't
trial.
take the chance of
That's
looking
right.
so stupid.
What is that, again, that number you just gave?
That rules of
Six,
evidence.
601.
Rules of
That's on your
evidence.
paper
okay.
there. General rule of competency of witnesses.
The right to have a witness.
Yeah. Basically, anybody can be a witness. There's very, very few exclusions to a witness. And that's what that paper's telling you. It's saying that they've actually deleted some of those prior things that excluded witnesses. And now pretty much anybody can be a witness, and it's up to the jury to determine the competency of the witness. And if you go up there and say, that name on that piece of paper is not me, you know what? The jury's going to think you're stupid. And no, they will never believe anything you say. There's a guy in Hawaii that did that. After I offered it, I sent him everything I had at the time. And he chose to follow these guys out in the outer islands. And they had a group, and they said, I'm a real life flesh and blood person. That name printed on the paper is not me. And that was their whole defense. So it really gets kind of dumb in the Patriot movement. And you can see one of the judges and the lawyers laugh at us. So we have to show them we're not into that category. We're not going to do that. And we're not afraid of them. We'll use what the law is, just strictly the law. We got plenty of ammunition there, more than enough. Okay, any questions on the table of parallel authorities?
Well, I just had something to pertain a little bit in that question, what you just said. For those of us who have gotten a license with the state to do a particular thing,
Yeah.
like myself, I'm a realtor, does that obligate me in any other way?
No.
Okay.
What would it obligate you for?
Well, I don't know, just because contracting with the state or something.
No.
Only within the realm of contract.
Yeah, only within the realm of the contract. Also, we have that Supreme Court ruling now, a 1988 case, that says somebody who contracts with the state is not liable for the federal income tax. Read the criminal complaint. It's right there in the criminal complaint. It's a 1988 case, South Carolina case, kind of thing. And that's why I say, I got on the Roy Tuckman show in Los Angeles, and I told him about that case, and he says, well, maybe they just forgot to tell state employees that. And they just happened to forget to tell them that, gee, they didn't really have to pay the income tax. It's strange, I mean, because here the Supreme Court knows this stuff, and yet either they feel like they can't bring it to the fore, it has to be brought before them by somebody bringing their case up through the lower courts to the Supreme Court. But in that particular case, that issue was brought to the Supreme Court in 1988 on a particular case. And the court happened to mention that employees and people under contract with the state does not make them, they're not liable for the income tax. So maybe it's kind of like a signal to everybody, hey, you guys pay attention to what's going on up here. I don't know. I don't know what their reasoning is. I don't even know who wrote that opinion, but it's from the U.S. Supreme Court. Yeah, Joe.
Bill made a mention a while ago, table of authority has to match up with, and I didn't catch the rest of it.
Well, you got the one side on one authority, the USC's, United States Codes. On the other side, you have the Code of Federal Regulations.
Those have to correspond together.
Well, no, they tell you which corresponds to which.
Okay, that's what I was probably missing there.
Yeah. If they got a code section here, a line across, it will tell you what regulations correspond to that code section. Okay, the rule of competency, you've got a paper on that. It's a good paper. Federal Rules of Evidence. You have that paper because you probably want to go over it. It's a little bit more complicated, but pay attention to the scope and the purpose and construction. These rules govern proceedings in the courts of the United States and before United States bankruptcy judges and United States magistrate judges. To the extent and with the exceptions stated in Rule 1101. Okay. Purpose and construction. These rules shall be construed to secure fairness in administration, elimination of unjustifiable expense and delay. So in other words, if they're going to ask you to go to Alaska to get a certification on a document, that's unjustifiable expense and delay. To hunt down people to get certification. I mean, if your opponent wants to challenge that document that you're providing as evidence, let him challenge it. Until he challenges it, it stands. And promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. So we're talking about truth here. How many judges are concerned with truth? Rule 103, rulings on evidence. So this is when a judge rules on evidence. If you make an objection, if there's an objection made to a ruling on evidence, in case the ruling is one admitting evidence, a timely objection or motion to strike appears of record, stating the specific ground of objection if the specific ground was not apparent from the context. So in other words, if you are objecting to some evidence that they're trying to admit, you file a motion of objection to strike, motion to strike, and then you have to state the specific grounds. You don't just make general statements. Offer of proof. In the case the ruling is one excluding evidence. So you want to put in evidence and then the judge excludes it. The substance of the evidence was made known to the court by offer or was apparent from the context within which the questions were asked. Okay, there are things you can stipulate to. Do you know what the word stipulate means? I mean, you agree. Okay, the prosecutor or the defendant's lawyer may ask you to stipulate to certain things. Larkin Rose stipulated to everything the prosecutor wanted him to stipulate to. That was kind of dumb, but you know, I would challenge everything because we have so much stuff we could challenge, and almost all their stuff is bonus. but I would challenge anything that they ask me to stipulate to. I would look at it and see what the grounds for challenge. Once the court makes a definitive ruling on the record, admitting or excluding evidence, either at or before trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. So you might want to appeal, depending on what side you're on. You're on one side or the other. You can preserve a claim of error for appeal court. So you need not to renew your objection. So you file an objection to something, a ruling, say the judge admitted evidence that you thought was not admissible, and you objected to the judge's ruling. Well, once the court makes that definitive ruling, you do not need to file another objection. You can preserve it for appeal. What you do is say, Your Honor, I take exception to the ruling. I wish the transcriber to make note that this issue is one I wish to preserve for appeal. You don't have to make another objection. Record of offer and ruling. The court may add any other or further statement which shows the character of the evidence, the form in which it was offered, the objection made, and the ruling thereon. It may direct the making of an offer in question and answer form. Oh, okay. Making of an offer in question and answer form. So in other words, if I make an offer to question and get answers, so you can do that. You can make an offer to for questions and answer form of resolving the problem. Hearing of jury. Okay, that's where a lot of these things are, you're supposed to keep them outside the hearing of the jury so that these arguments on the admissibility of evidence are not heard by the jury. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. So in other words, you could bring a notice, you could present a notice of plain error to the judge because it's affecting your substantial rights. If the judge makes a ruling on admissibility of evidence, that's what you can do. Do a notice to the court. Substantial error. And tell them what rights it affects. My right to present these court cases that you're relying on. Preliminary questions, Rule 104. Questions of admissibility generally. Preliminary questions concerning the qualification of a person to be witness. So this is the, what was it Bill was talking about?
Voir dire.
Voir dire. You're going to get to the voir dire. So you get the questions, preliminary questions, to see if he's qualified to be a witness, or for the existence of a privilege, or the admissibility of evidence. It shall be determined by the court, subject to the provisions of subdivision B. And that's right below it. Relevancy conditioned on fact. When the relevancy of evidence depends upon the fulfillment of a condition of fact, the court shall admit it upon or subject to the introduction of the evidence sufficient to support a finding of the fulfillment of the condition. So it's got to be for some condition that you're trying to fulfill to show something in your favor. Hearing of a jury, you don't do these things in the hearing of a jury. Testimony by accused. The accused does not, by testifying upon a preliminary matter, become subject to cross-examination as to other issues in the case. Okay. Weight and credibility. This rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. So we have the Supreme Court rulings. This rule does not limit that right of the party to introduce those Supreme Court rulings, because it's relevant to the weight or credibility of the claims of the other side. Claims of the other side of the 16th Amendment allow a tax on everybody. Rule 105, limited admissibility. When evidence is admissible as to one party or to another, or for one purpose, but not admissible as to another party for another purpose, is admitted, the court, upon request, shall restrict the evidence to its proper scope and instruct the jury accordingly. Okay, okay, here, let's go down to the facts, Rule 201. This rule governs only judicial notice of adjudicative facts. These are facts that can be ruled on. Kinds of facts. A judicially noticed fact. So you notice the court judicially. The court is hereby on judicial notice that this fact is one I wish to present. Okay, what does it say about that? A judicially noticed fact that you're doing must be one not subject to reasonable dispute, in that it is either one, generally known within the territory or jurisdiction of the trial court, or two, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So a judicially noticed fact, you're presenting the fact, must be one not subject to reasonable dispute. Okay, so I don't think it's reasonable to say, to dispute that these Supreme Court rulings apply to a tax evasion case. It's not reasonable to say that, to dispute that those cases have any bearing on a prosecution of tax laws. So you notice the court may take judicial notice whether requested or not. So the court may do it on their own bat. A court shall take judicial notice if requested by a party and supplied with the necessary information. So you want to notify the court, this court is hereby noticed that this fact is being presented by the plaintiff or the defendant. And I think we should use that.
Is that done with letters to the judge?
Notice to the court. Not personal letters to the judge, because it may be that judge or it might be another judge.
A written form.
Yeah, it's a written form, yeah. You notice them before you ever go to trial.
Okay.
Yeah.
I think that's what she was asking, wasn't it?
Yeah. But it's not to an individual judge, it's to the court that's hearing the case. You know, the judge may fall over and die, and they send another judge to take his place. So you want that notice to be judicially noticed. This court is hereby judicially noticed that this fact exists.
You serve those on the clerk of the court?
No, you serve them with your case number, just like a regular filing. And you do a notice, judicial notice to the court. And then you list the facts you want to judicially notice them. Actually, when I think about it, I think we should do that in our filings. when we're the plaintiff, we should judicially notice the court of these facts. And then let the court provide the answers. Because we have the 2002 Federal Maritime case, the Supreme Court says that the court shall present all the findings and conclusions on all matters of law, fact, and discretionary matters. In a civil action or proceeding, the court may instruct the jury to accept as conclusive any fact judicially noticed. So in other words, if you notice the court on the rulings of the Supreme Court that said the 16th Amendment did not confer any new taxing powers or did not confer, bring any new subjects under the ruling, and then you list and quote those court cases, you judicially notice the court on that. And then the court shall instruct the jury to accept as conclusive any fact judicially noticed. How many lawyers do this? I bet you hardly any lawyer. I've seen them. Anyway, okay, so presumptions in general civil actions and proceedings. In all civil actions and proceedings not otherwise provided for or by these rules, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption. Okay, so if Christine there is an IRS agent, and I create a presumption on her that she does not have a authority under 7608, and I present her with a 7608, now she's got to answer that presumption. She's got to say where she got her authority from. Creates a presumption in law. And we have court cases that say the same thing. So I could do that against an IRS agent in court, but you do it on paper before you ever go to court. Our court system is set up so that we don't have to go to court if there's no crime here, if there's no subject matter jurisdiction for that court to operate. Subject matter jurisdiction says that you are a person who willfully, knowingly committed a crime. It has to cite the crime. Has to cite the penalty. It has to cite the regulation of the statute. If all that stuff is not present, this court has no subject matter jurisdiction to proceed. It has to have all that stuff lined up. That's what the prosecuting attorney is supposed to do if you're the defendant. If you are the plaintiff, you have to line all the stuff. Make sure that all of your complaint specifies everything that agent did wrong. If you're suing the IRS agent in his personal capacity. And I told you the 4 things you have to stipulate or state in your pleadings. And then your causes of action, remember all those? And then once you have done that, that creates a presumption that what you say is true. That's why the court ruled that way. It's true, and they have to assume that it's true until it's rebutted. And if they don't rebut it, it stands. So even an allegation stands if it's not rebutted. There's a lot of more work I think the Patriots can do on this line, because the judge is Erwin Schiff says he's got 3 motions before the court, and the judge hasn't answered any one of his 3 motions. I've read a couple of his motions, and they're very clever, very good motions. And I can see why the judge doesn't want to answer. But now Irwin should be applying the Federal Maritime Port Authority ruling by Judge Clarence Thomas. He should be applying that to the court that he's in. Demanding that these things be explained by the judge. Okay, we're just going to pause for a second. Right now, we're crossing back and forth between being a defendant and being a plaintiff. But we can use these rules in both instances. I know how to do it. Okay, we're ready to go. So, definition of relevant evidence. So now this would be important. What's the definition? Relevant evidence means evidence having any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So in other words, it's relevant evidence if it's going to have effect on the outcome of the trial. Even if it moves the jury a little bit this way or a little bit that way. If it's going to do that, it's relevant evidence. Rule 402, relevant evidence generally admissible. All relevant evidence is admissible except as otherwise provided by the Constitution of the United States, by act of Congress, by these rules, or by other rules prescribed by the Supreme Court pursuant to statutory authority. Evidence which is not relevant is not admissible. Okay, so you've got all these things that you can introduce as relevant evidence. You can introduce all these Supreme Court rulings. You can introduce the statute and regulation, create a presumption on the other side that they don't have a statute and regulation to do any collection actions. You can back that up with 7608. So now you've got two pieces of evidence showing that the IRS agent doesn't even have authority to collect Subtitle A or Subtitle C taxes. Yeah.
Chuck, when you're the defendant, the presumption is I'm going to use the IRS, what the IRS says is accurate unless, or is, what I'm the right word, true, accurate, whatever, unless it's rebutted. That's what you just said, right?
Yeah.
Okay. My question is, you cannot disprove a negative. And that situation arises often because...
But see, we've gone beyond trying to prove or disprove a negative. We've gone beyond that. We've got all of our positive rulings. If our rulings are correct and they're not challenged, then it creates a presumption in the IRS that they are imposing a direct unapportioned tax. They've been doing it for years on people. It creates a presumption on them.
Yeah, you're saying there's a more basic level, but given that it's already in the context of defendant, they're the plaintiff, okay?
Well, have they ever said, has the IRS ever created a presumption in the case that you owe a direct unapportioned tax? Okay, they don't. They don't do that. They want to talk about other things. But we want to stay right on point. The direct unapportioned tax. Don't let them dissuade you. And we can prove it, see. Now we create the presumption on them that they have to rebut. Relevant evidence generally admissible. It says all relevant evidence is admissible, except if it's prohibited by the Constitution of the United States or by an act of Congress or something like that. Exclusion of relevant evidence on grounds of prejudice, confusion, or waste of time. Now, they might try to say that this is this evidence of your Supreme Court rulings is not relevant because it's confused and it's a waste of the court's time. And you say, you respond and you say, it is relevant to the issue and it is not a waste of the court's time because this evidence will persuade a jury in the other direction. It's not a waste of court's time. How can Supreme Court rulings affecting your trial be a waste of the court's time? Character of evidence not admissible to prove conduct, but that's for evidence to prove conduct. That's character evidence. That's what the judges want to limit the testimony for the defendants to, is limited to character evidence. And, you know, you can get in front of a jury and say what a great guy this guy is, you know. He doesn't beat his wife, he takes her to dinner once in a while, buys her flowers. And all that's irrelevant to whether or not he did the act or didn't do the act. And the jury has to go on the facts and the law, not on whether he's a nice guy. So the character issue is, I think, would only be relevant if his testimony was in direct contradiction to somebody else's testimony, like yours, George. Then the character issue would be relevant. You could get character witnesses on your side, and then let that Fruit Loop get character witnesses for himself. He'd probably have a tough time getting his mother to be a character witness for him. You ever hear about the guy that had 3 mothers because they had to take shifts every day to love the guy with his face? A guy that only 3 mothers could love in 8-hour shifts.
What were they like?
The mothers? They always said, my Johnny would never do that. How many times have we heard that? Oh, I know, I got grandkids. Okay. I want to go through some of the scope and purposes of the rules of court for civil action procedure. Rule 3, commencement of action is commenced by filing a complaint with the court. You know how to file a complaint. Rule 4 is the summons. The summons shall be signed by the clerk. Bear the seal of the court. Identify the court and the parties. Be directed to the defendant. State the name and address of the plaintiff's attorney, or if unrepresentative, of the plaintiff. It shall also state, it's not in your papers.
Oh, thanks.
All right. I'll just I'm going to skim through some of these, but there's your summons in Rule 4. How you service the complaint, you service that. Now, when you file your complaint, you take it, walk it into court, and you probably will want to prepare your cover sheet. It's a civil cover sheet, they call it, civil cover sheet. And it's very easy to fill out. You fill out top, then you're going to pick out, like in a case where he deprived you of a constitutional right, you would list a constitutional issue. I think you got 1 of 4 choices. And a constitutional issue takes precedence over all other kinds of cases. So you would get first dibs on the judge if it was a constitutional issue. So once you do that, then you take 2 copies of the complaint, your brief, your evidence, your affidavits, 2 copies of each to the court, 1 for the judge, 1 for the court. Then you have a copy for the defendant, you're going to serve on him. Then you want to keep probably 2 copies for yourself. Okay, and you'll have them all signed with your signature notarized on them, just to be safe and everything. Get that all done. Then the court clerk will sign the summons. He might give you 3 or 4 copies so that you, in case you fail to serve the summons the first time, you have a couple extras to serve on. And then it's your job to serve it on the defendant. And you have to have it served personally. The first time. After that, you can serve it by certified mail with a proof of service by somebody who puts it in the mail, puts it in the envelope, seals it, hands it to the postal clerk, and it signs a proof of service to that effect.
Now, if somebody else signs for it when it comes in, is that as good as being served to the person?
What, yes, once you do the initial service of the summons and complaint, that has to be done by a process server, or somebody who can walk up to them and say, here, we're served.
How about
Right.
the age of 18? Did you say over the age of 18?
Yeah, over the age of 18, who's, not interested in the case. It has to be a disinterested party.
They didn't require me to do that when I filed a civil. They just said if you mail it certified mail, it'd be okay. So
To who? To who was this?
This was at the Secretary of the Court.
But who was this?
The defendant was the Commissioner of the IRS. And,
Okay,
and
in the case of the United States, you can serve it by certified mail. That is right.
They were
Is
right.
it certified or proof? They could refuse certified mail and say they never got it.
No, they have sites for it.
You have a third-party mailer. I did. I had a third-party.
They'll take it, the United States will take it in.
When I receive certified mail, I always sign receipt. I never sign my name.
Okay. Well,
Registered, you have to sign your name.
No, I don't.
the postal,
No, okay.
but when you file that first summons and complaint, you have to do it by a process server unless it is to the United States, because they have a rule, a law that says you can file it by registered mail or some other process other than having a regular summons server.
You have to use a process server unless what?
Unless it's against the United States.
Thank you.
Yeah.
Is there a listing of process servers somewhere, and do you just get it on the internet or library?
Oh, you can get them on the internet.
Okay.
I had one served in Kansas City by a process server, and they actually had to do it twice. Because first time he served the complaint and all the documents, but he didn't serve the summons. If there's no summons with it, there's nothing to tell the guy he's got to appear in court, right? Now the summons says that for an ordinary person it's 20 days. The IRS agent has to, or the defendant has to reply. But if it's the U.S. government, they give them, I think, 60 days to reply to a summons.
Is that someone you got signed by a judge?
No, it's signed by the clerk of the court.
Okay.
Yeah. And he, like I say, he'll give you probably, you can ask him for 3 copies, 4 copies, because you might have trouble getting the summons served. So you want to have an original signed and stamped by the court clerk. And you might need 3 or 4 of them. I needed 2 at least for that one guy. So now in the service of summons, there's also a waiver of service thing, but I don't think you need to do that. I've done that, and it really hasn't brought me any advantage or anything. They never answer it. But actually, see, the purpose of the waiver of service is the duty of the defendant to save the cost of service. Well, if you can get service for $30 on your local county, or you could do it for free by having somebody walk in, why do you have to worry about the waiver of the cost or waiver of service? So in most cases, you're not going to do that. It takes up a lot of time. It's more effort than it's worth. Rule 4, summons. Upon or after filing the complaint, the plaintiff may present a summons to the clerk for signature and seal. So you filled it out, the summons. You can get those off the internet. Like if it's the Western District of Michigan, you can get that summons on the internet. Then clerk will put the signature and seal on it. The clerk shall sign, seal, and issue it to the plaintiff for the service on the defendant. So now it's your responsibility to serve it on the defendant. Service with complaint by whom made. A summons shall be served together with a copy of the complaint. The plaintiff is responsible within the time allowed under subdivision M. I think that, you have to get the summons service probably within 60 days, something like that, or 90 days. And shall furnish the person affecting the service with the necessary copies of the summons and complaint. Okay? Service may be effected by any person who is not a party and who is at least 18 years of age. At the request of the plaintiff, however, the court may direct that service be effected by the United States Marshal. The court will never do that for you. It never will do it for you. But you can always try it. An individual has a duty to avoid unnecessary costs of serving the summons. But I still think that's going to be more trouble than it's worth. I printed all that up, did it, mailed it, and you never get an answer, then you got to serve the summons and everything anyway, and the court will never address the issue. Just don't even bother with it. Service upon corporations and associations, that tells you what you have to do. The rules that are going to, okay, you have to serve and filings of pleading. So whenever you do a pleading after that, you have to, I would recommend you just take it into the court if it's within like 30 miles or 40 miles. Drive it to the court. You just walk in. You got, if you got a pleading, say like it's an answer or it's a motion for a summary judgment or it's a motion for dismissal of the other party's claim or something. You have 4 copies. You walk it in, you give 2 to the clerk of the court. She'll stamp them, mark in. They're stamped and time stamped right then. So if there's a time problem, you right away you get your stuff right in. Then you take the 1 copy, it's already stamped by the court, you mail it by certified mail to the defendant, you keep a copy for yourself. It's all done, all in one swoop.
Is she to stamp each page?
Yeah,
If there's
not each page, no, the front cover sheet of each one.
the front,
The cover
but
page.
not the back, the last page?
No. You've got them all stapled together
Right.
in a package, so you got 4 of them stapled separately. I actually, because I did so many of these, I bought me a real nice stapler that I can staple 60 pages together or something like that. But I had to do it because I was doing so much. But you take it in, you get it served by certified mail by somebody, has to sign a proof of service. Then you have to send the proof of service to the court.
One is for the prosecutor, one is for the court.
I didn't say prosecutor, I said you're suing them, right?
Right.
Are you thinking defense, offense? What are you thinking?
Well, I'm thinking anytime you send something to the court, you
Yeah,
have to
but-
get it stamped.
But
You
the
make it 4
prosecutor,
copies.
there is no prosecutor in the plaintiff, in the case where you're suing an agent.
Okay, so where are those 4 copies going? I'm just trying
2 to the court, 1 to the defendant, 1 for yourself.
Because when I give one to the court for anything, they always say, or if I'm going to give 2 to the court, they always say, we only need 1.
Oh, well, fine.
Oh, okay, so I'm just trying to
But
clarify
in
what
US District Court, they'll probably tell you you need 2. 1 for the judge and 1 for the court.
Mark judge. And for the court.
Yeah. They used to ask for 3.
Okay.
Now they say, well, we've computerized it now, you only need to give us 2. You'll have to pay a fee up front, $250 for filing a complaint.
Okay.
That's not a bad deal.
Are you saying in effect 4 originals? Is that what you're really saying or not?
No, mark 1 original for the court, 1 is copy for the judge, 1 for the copy for the defendant, and copy for the plaintiff. Mark them copies. Do mark them because if you don't, The lawyers on the other side may jump on that particular issue. Lawyers will grab at any straws that they possibly can. If they got nothing to grab at, you know, they got problems. Yeah.
When you're filing against an agent, aren't you required to notify the agent's the boss and send a copy to the Department of Justice too?
Depends on if you're suing the United States.
Okay.
What if you're suing an IRS agent in his personal capacity?
Notify his mother and father.
And she'll say, my son couldn't have ever done that.
Is it true that you need permission to sue the United States?
Well, you have permission by statute.
So that,
Statutes, 7433 is one of those statutes that permits you to sue the United States. But it limits the damages. Limits the damages down to where you may not get much of anything at all. So you have to fight that through.
Yeah, on the cover sheet that they made me fill out for the court, it only had a box for, you know, who your defendant is in the United States. So that's how my...
So you did
Although
you did a 1983 lawsuit? Okay.
I don't know what kind of lawsuit, it was this complaint against
Yeah, but it has to cite something that the United States broke.
oh yeah.
So what was the law they broke?
552A,
Okay.
falsification of records, failure to correct records,
All right.
and 63.
But if it's against the United States, it's a 1983 suit. They call it, because that's the code section that it's authorized. Look in the code. The section is 1983. There's one for 1983, 1984, 1985, and those are not years, those are code sections. And I think they're in maybe Title 18, Title 18.
Yes.
So those are particular kinds of lawsuits, yeah.
But I actually sued the Commissioner of Internal Revenue Service and several agents as defendants.
Okay, did you sue them then in their official capacity?
Didn't state specifically, and their motion to dismiss assumes that I was doing it in their official capacity, and I would write this motion to strike. I'm specifying that they're in their individual capacity, and my documentation refers to that several.
Well, then it wouldn't be a suit against the United States. If
I know, what I'm saying is, when I got the cover sheet and I first filed it, they made me make a box on there, check a box.
Yeah.
Who it's against.
Okay.
And then there was no individuals on there. I guess it was an other, and I could have probably. If I had
Could have been
said-
other, yeah,
I
because
should've-
sometimes I have to check the other box.
Okay, that's what I should have.
But if you're doing it against an individual, you're probably filing a tort action. A tort is an injury to you. And if an agent steps outside of his authority, and you can file a tort action against him. And that should be on the cover sheet, the civil cover sheet.
I screwed a lot of that up there.
Well,
where do we find the tort action?
you can ask the judge to explain what corrections you need to make on it. Haynes versus Burke. Yeah. See, the thing that the judge hates about that is you don't have to pay any more money to refile. You already paid your $250 going in.
You actually did that on one of these cases, right, where you resubmit a complaint or correct a complaint? Is that what that would be for?
Yeah, that would be for, yeah.
you have multiple people named on one tort action.
Yeah, but I've already said, it's better if you keep your lawsuit as simple as possible.
Do them individually then, you say?
Well, yeah, well, like, what I'm saying is, if you got multiple plaintiffs and multiple defendants, you have to allocate the damages of all the defendants, and you have to allocate them to all the different plaintiffs. And it's going to be much more complicated. If you got 5 plaintiffs, why doesn't each plaintiff file his own lawsuit?
How about one plaintiff and multiple defendants?
Well, it's still complicated, and the judge can throw it out if you don't allocate the damages among the defendants. So why wouldn't one plaintiff file one lawsuit against one defendant?
Because one individual IRS agent civilly doesn't have but a few grand to get awarded to you. How about that?
He doesn't have a few grand?
The reason that the answer to the question that you're asking to me would be that if you go for the revenue agent, he has X number of dollars that you may be able to get.
Yeah.
If you go for a supervisor, he probably has X plus Y. If you go for the territory manager, he's got X plus Y plus Z. If you go for the guy at Tikva, he's got more.
Yeah.
That's the answer. And now, what would you do?
Well, I'm telling you, if you don't allocate those damages between all those people, the judge can throw your whole lawsuit out.
I would take the lowest guy, take the money I win from him, go after the second guy, take the money I win from him, go after the third guy.
Just work up the ladder.
They have liability insurance of $1 million.
Personally?
Probably.
Is that
They
right?
carry.
They probably
I
do.
sold that by 280.
Okay.
And bonds on it.
That's good news.
That's probably true.
That's damn good.
Deep pocket.
And bonds too.
Better to run in than hide in the docket, isn't it? Okay, those are just service rules, getting pleadings served. Do it the easiest way you find. Okay, then there's a rule 6 that goes for time periods. Here, let me read this to you. In computing any period of time prescribed or allowed by these rules, by the local rules of any district court or order by court, or by any applicable statute, the day of the act, event, or default from which the designated period of time begins to run shall not be included. So in other words, if the defendant filed an answer, now you have a time period to run, and you have a time period where you have to file a response if you're going to file it. If you don't file a response, you're going to lose the case. Okay, so you have, but it says the day that that the defendant files his answer does not include in that time period. Okay, the last day of the periods so computed shall be included unless it is a Saturday or Sunday or a legal holiday, or when the act to be done is the filing of a paper in court. Okay, so the last day will be computed. When the period of time prescribed or allowed is less than 11 days, intermediate Saturdays, Sundays, and legal holidays shall be excluded in the computation. So, in other words, 11 days would actually give you 2 weeks. If it's less than 11 days, 10 days would give you 2 working weeks to respond. Okay, then it tells you which are the legal holidays. Computation of time, Rule 6. All motions shall be signed in accordance with Rule 11. So if you're a pro se plaintiff, you got to sign the bottom and have a printed date and a signature. Now, here's the interesting part: is the general rules of pleading. And this is where the ones, starting with Rule 8, you really need to read these. You can get those rules online. We downloaded these and printed them all out. They're very nice, readable, and once you get them, you're going to be underlining certain things that you're going to think is important. A pleading which sets forth a claim for relief, whether an original claim, counterclaim, cross-claim, shall contain So that's a claim for relief. It tells you what you have to file there. And that's for, like, the defendant will file for a summary judgment to dismiss. He's asking the court to dismiss your claim, relief, and it's got to be a short and plain statement on the grounds upon which the court's jurisdiction depends, or a short, plain statement of the claim showing that the pleader is entitled to relief. Entitled to relief for what reason? A demand for judgment for the relief of the pleader seeks. So the pleader or the defendant will have to ask for relief on these things. Now, defenses, form of denials. Now, this is a very important one. A party shall state in short and plain terms the party's defenses to each claim asserted, and shall admit or deny the averments upon which the adverse party relies. If a party is without knowledge or information sufficient to form a belief as to the truth of the averment, the party shall so state, and this has the effect of a denial. This is what I told you yesterday. You must deny or state that there is insufficient information on which to form a determination, make a determination. That is considered a denial. Denial shall fairly meet the substance of the averments denied. Okay, you cannot just say, I deny, paragraph 11. I deny it. There's no substance to it. We did this against a lawyer here in Lansing, and he just said, I deny. And so we said, since we stated in each paragraph, we said, since the defendant had presented no substantial denial, no substance to it, that we're accepting it as an admission. They didn't like that at all.
Where online can you get that?
Federal Rules of Court. Just do a search for Federal Rules of Court. They're also, I think these are stated in the USC, but I'm not sure. Okay, so your defenses have to have substance to the denial. The only way you could get around that would be to say that the plaintiff or the defendant did not supply enough information on which you could make a determination. That way he would have to explain more. If he says that you did not have a claim on which relief could be denied, you can say that the defendant did not provide enough information on which to make a determination on that. So that's a denial on your part too. And it nullifies his claim. Effective failure to deny. If you fail to deny a paragraph, averments in a pleading to which a responsive pleading is required, other than those as to the amount of damages, so forget about the amounts of damages, are admitted when not denied in the responsive pleading. So if you don't deny it, they're admitted. That's why I told you if somebody does affirmative defenses against you, you have to cover every one of those, because if you fail to deny it, it is admitted by the court. And then that particular denial, if it's sufficient to throw the whole case out, judge throws it out. You're cooked.
You're basically better off doing too much objection rather than not at all, right?
Well, you can't not at all do objections.
No, I mean, you said some people set in court, you don't object at all.
Well, this is on paper.
Oh.
We're talking about paper here. This is all on paper.
It's all pretty much before the court case, isn't it?
Yeah, you got to get to court. It's a long ways. Oh, I did not explain to you, give you an outline of that. I got to do that before we finish today. Okay, let's go. Let's say the court system is basically a long box. If you enter here Okay? What's the first thing that happens? Your complaint and summons, right? Okay. You do that, you get them served. The next thing you got is an answer from the defendant. Okay, now he answers. Now he may not answer your complaint. He may claim that the judge should dismiss this case for other reasons other than in the complaint. And one of the common things that they've always used is 12b-6. So please be aware of 12b-6. Failure to state a claim on which relief could be denied. Failure to state a claim upon which relief could be provided. So that'll be one of their big claims. Now, under Rule 12, and they're expecting you to fall through this trapdoor. What's happened in the past, this is trapdoor, and this is called the summary judgment. They want you to drop out here, bye-bye. So they want you to fall through the trapdoor. You have to survive summary judgment. How do you survive 12b-6 claim? 12b-6 is a rule. Court rule. It's right here in the rules of civil procedure. Let me look at 12b-6. Defenses and objections by pleading or motion. Motion for judgment on the pleading. So they're going to make a motion to dismiss based on the pleadings. Okay, if you go down here, you will find 12b-6. Okay, 12 is Rule 12. B is paragraph B. And then if you go down through B, you'll find 1, 2, 3, 4.
Small b.
Maybe, yeah, you know what? It is a small b. You're right. Okay, C, D, E, F. Oh, it's a small b. Okay, sorry, didn't stop. Okay, here it is. How presented B. And then you go through this and it's 1, 2, 3, 4, 5, 6. Failure to state a claim upon which relief can be granted. That's their thing that they've been throwing the patriots out of court for years and years. But what does it say? Later on, here it says, if on a motion asserting defense number 6, 6, that's the defense, to dismiss for failure of the pleading to state a claim upon which relief can be granted, matters outside of the pleadings are presented. So they're going to ignore your pleadings. They want to ignore your pleadings, and these are matters outside of the pleadings. Okay? So the lawyer is perpetrating fraud here in the court. He's saying that he has reason to file a claim for dismissal under 12b-6 because he's saying he has matter outside of this complaint, and that matter is sufficient reason for the judge to dismiss it. Now, matters outside the pleadings are presented to and not excluded by the court. The motion shall be treated as one for summary judgment. Didn't we say summary judgment? And disposed of as provided in Rule 56. And all parties shall be given reasonable opportunity to present all materials made pertinent to such a motion by Rule 56. Now what does Rule 56 say?
Sworn statements.
You have your opportunity.
Your opportunity, but I'm going to actually read your Rule 56. We're going to get into that now because that's going to be crucial to surviving because that's going to be one of their claims. And basically, if he has no reason, no evidence, and no sworn statements or testimony that he can provide that would support his claim that 12b-6 is sufficient, if he has nothing to support that claim, he's perpetrating fraud in court. And you should say so. So now if the judge issues it on 12b-6 and there's nothing to support that, and he grants the dismissal, the judge is acceding to fraud. He'll do it. But you know what? You got him trapped then. Fire him. Yeah, fire him. Well, that's what we're doing. Let me go back to
Rule 56.
Yeah, I'm trying to find Rule 56 here. Ooh, don't tell me I don't have Rule 56.
I got it here.
You do? Yeah, please. I would like to. Maybe I...
This is Eastern Division, not Western. But
That's all right. It's the same rule. Rule 56, summary judgment for claimant. So for A is for the claimant, B is for the defending party. So this is the defendant. He's making this claim. He says he's got a reasonable cause to dismiss. A party against whom a claim is asserted or a declaratory judgment is sought may at any time move with or without supporting affidavits for a summary judgment in the party's favor as to all or any part thereof. Okay, it says with or without supporting affidavits. He may move. Motion and proceedings thereon. The motion shall be served at least 10 days before the time fixed for the hearing. Okay, so there should be a hearing scheduled on 12b-6. And he should file for the hearing.
The defendant.
The defendant. Because he's the one that's filing it, and he has to file it 10 days ahead of time. So it means he has to file it within the required time of the answer, and then motion for a hearing.
Hearing to dismiss.
Yeah. The adverse party, prior to the day of hearing, may serve opposing affidavits. They may serve opposing affidavits. So now we're talking about facts. Remember, we were talking about law and fact. That's what we're going to argue in these cases. So opposing parties may file the affidavits. But remember, in the prior paragraph it says he may seek for summary judgment with or without supporting affidavits. That's when he's asking for summary judgment. But now we move on to the motion and the proceedings thereon. Now we have to do affidavits. Both parties have their opportunity and evidence. Now, the judge can only make his determination based on the evidence, the stuff admissible in trial.
Chuck, are you saying that everybody has to be noticed 10 days before?
Before the hearing.
Okay, and that's the hearing for the summary judgment?
Yeah. Yeah. And for the, that will give you time to present your affidavits and evidence. You can file copies with court on paper. And if it's a hearing, see, the judge never does that. The judge has never given us a chance for a hearing. He just makes a ruling. Actually, we do file motions opposing the summary judgment. But we should file our affidavits with our opposition motions.
It would seem to me that you'd know 10 days in advance that he's going to 12b-6. I mean, if he has to give you a warning that there's going to be a summary judgment.
Hearing, yeah.
Yeah, hearing.
Yeah.
Well, you would, I mean, that would send up a red flag that you're going to 12b-6 you. So you want to make, the court know that you have affidavits?
Yeah,
Okay.
yeah. Well, it's like what we have done in the past, we file our affidavits right at the beginning when we file our complaints.
Okay.
Now, the trouble with that is the court pretends like they never filed the affidavit. They never read the complaint. They're only looking at this. That's what they pretend, yeah.
How do you get around it?
By refiling the affidavits and all your evidence. Refile it. Doesn't matter if you did it up here, do it again. And say, this is the reason why he does not have a claim under 12(b)(6 because of this affidavit, this evidence. And you write, I hope you all know how to do an affidavit. You cannot testify to something that you don't have personal knowledge of. In other words, if you don't have personal knowledge that the agent doesn't have a delegation order from the secretary, supposing you don't have personal knowledge of that, what can you say in an affidavit? I requested an delegation order from the agent, and he refused to give me one. He refused, which created the well. Don't get into legal conclusions or presumptions. You could state that in your filing. Now, with the affidavit, you're going to file a motion of opposition, and in the motion of opposition, you can make those statements. Like, that created a presumption that the agent didn't have a delegation order.
It's an affidavit with witness and notary?
Yes, you have to have your signature notarized on it. You're going to be your own witness.
So, you make this statement to the notary?
No, to the court.
To the court for the written affidavit?
Yeah.
Notary's just gonna
So it's a notarized statement.
Yeah, but the notary just notarizes that you're the person who signed it in the presence of the notary.
Of my personal knowledge.
No, it has nothing to do with your knowledge of anything, just that you're the one who signed it. That's your signature on a paper. That's what the notary is saying. So now you have an affidavit with your signature and a notary saying that you signed the affidavit under penalty of perjury. That affidavit is addressed to the court. I mean, it's attached to your pleading to the court to deny summary judgment. Affidavit is one of those things that you can present for your argument. Now, supposing the agent has no affidavit to oppose your affidavit, he loses. Automatically, he has to lose. That's why I'm telling you this is a mechanical process. I personally know a couple lawyers, and I'll tell you, some of these guys would make a pet rock look smart.
So you're saying we gotta file a complaint the minute we walk in, just automatically before you hit the trap door in the summary, file another one?
Well, no, not automatically. You can file your affidavit with your complaint, but if they come back and they say, motion to dismiss on 12(b)(6), they'll send a copy to you. You'll get it in the mail. See, he's got 20 days to answer your complaint. If within 20 days, if he doesn't answer within 20 days, you get a default judgment. Court should enter a default judgment against the defendant.